Hi listeners, it's Iram Ali here, immigration solicitor, starting the new year in 2025 with an apology to you all because I set up my channel this time last year and then I kind of disappeared. Where did I go? I got really busy in setting up my own law firm, and in October 2024 I set up Iram Ali Solicitors Limited. I was a consultant solicitor back when I started the channel, but now I'm very proud and very excited about having my very own law firm. So as of October 2024 I have my own setup. So that's where I have been extremely busy, but I do want to come back to you guys on YouTube and continue giving you free legal advice which is accurate and will help you navigate the immigration rules. So the topic that I've picked for today's video deals with child entry clearance, and what prompted this video is an inquiry from a lovely lady who came to see me in the office a few days ago, and she I think it's a care worker. She'd been here for a number of years. She'd made an application to the Home Office to have her children here. Application was refused because the test in which the Home Office applied to that application, the Home Office said that she did not meet. And once I looked through the application and the refusal, it was very clear that that had not been dealt with in the application. What am I talking about? I'm talking about the sole responsibility aspect of a child entry clearance application. Now, if you want to sponsor your children to the UK, they either need to be part of your own applications. If you're both coming in, you and your partner are coming in to the UK, and your child is coming with you, that's fine. If spouse is here and they're applying for the other partner with the child, that's fine. So responsibility kicks in when one partner is here, the other partner is in another country, and the partner here is sponsoring the child to join them, but not applying for their partner. Does that make sense? So, for example, husband is here, wife is in another country, child is with the wife, and the husband wants to sponsor the child to come to the UK. There is a different set of rules that apply, and the Home Office will look at before granting entry clearance to that child. Now, what are those rules? What is the test that needs to be met? There's two tests, so you have to meet one of them. So the first one is called sole responsibility. Now, the sole responsibility test looks at what level of control or responsibility do you have as the sponsoring parent over your child. Okay, so well, the obvious starting point for the Home Office is where is the other parent, and why is the other parent not being sponsored to come to the UK? And there's lots of reasons for that. You may be divorced from your partner. You may be separated. Partner may have died. Okay, those are usually the typical one of the three reasons why the other partner is not being applied for or sponsored to the UK. So if your partner has died, who's the biological other parent of the child, obviously you would need to provide a death certificate and then explain where the child has been living in the meantime, who they've been living with and what the arrangements have been. But that should be relatively easy for the child to be granted entry clearance to come and join the biological parent in the UK. If you're separated or divorced, then obviously the Home Office want to see evidence of that. And I have dealt with an application where the couple had separated when the child was very, very young. The sponsoring parent was the biological mum's partner who was in the UK. So he had sponsored her, but the child was not given entry clearance because mum didn't deal with the sole responsibility aspect of the application, and she'd applied and was refused through a different solicitor, not me, and then the other solicitor didn't think there was any merit in an appeal. Well, obviously there wasn't, because the sole responsibility test was not met. It wasn't even dealt with in the application, actually. So the Home Office, I think, may have been right to make that decision. So I explained this to her, and she said, well, my son was very, very small when my husband left me, and I didn't go through the whole rigmarole of getting the divorce. It was costly, it was timely, it would have been very stressful. I didn't know where he had gone, so I knew that he wouldn't engage with the court. You know, it's been over a decade now. I don't know where he lives now. And we were able to evidence all of that through getting information from different authorities, which included the child's school, GP, friends and family. And I'm sure an application was made to the court for a divorce based on the, decade of absence from the other partner. And it took a while to get those documents in order and get them through, but we eventually did do that, and we submitted a fresh application, and the Home Office did grant the child entry clearance, and it was a tremendous result for that family, and a case that I'll always be very, very proud of, because I remember that the lady who came to see me, the mum, she came to see me, I think it was like 10 to 5 on a Friday, and I was like, oh, I really want to go home. But when I met her, I was like, oh my God, she was suffering. It was awful. She felt so guilty that she'd come to the UK with her new husband, and her child was home living with her mum, and she had to just come, and then she applied and it was refused, and then there was no, the sister wasn't willing to do the appeal. She was in a state, an absolute emotional wreck she was. And I said, don't worry, I'm going to help you get your child here. And I did that. Now, the other one, which is a bit of a mouthful, is, so if you either have sole responsibility, or if you don't have sole responsibility and you're sharing responsibility with your partner, there must be serious and compelling family or other considerations making exclusion undesirable. I'm sure the Home Office can say that in less words, but here we are. What does that mean? That means that although you don't have sole responsibility for your child, so you're married, your wife is in another country, and one of the reasons why that may be the case is, your husband, your wife doesn't want to migrate to the UK. You have more than one wife, and according to English law, you can only have one wife here. Or there might be another completely different reason. And you realise, you've decided that it is better for the child to be living with you in this country. Now, a case that I'm working on at the moment is that his father is here. He's got a wife here, he's married here. He's got a child to another woman in his country. And she's been looking after the child as a boy. She's been looking after us for a number of years. She now has very serious mental health issues, and she is no longer able to look after the child. Therefore, a decision has been made between the two parents that it is better for the child to come and live in the UK with the father. And there are many emotional and physical factors that relate to her own health, which we would then have to demonstrate in evidence to the Home Office. So again, it's about the authenticity and credibility of the evidence that we submit to the Home Office, which will prove the circumstances under which the application is being made. So just an application on its own, or letters from family and friends, is not going to suffice. There needs to be concrete evidence from experts, which will give weight to an application, and that's what you would need to submit. So it's either sole responsibility or serious and compelling family or other considerations. Okay. All of that would have to be evidenced and then submitted with the application. Sometimes the Home Office will require DNA testing to make sure the child is your biological child. That I have seen that before. And very often the Home Office will ask for more additional information. based on the questions that they may have from the application and the supporting evidence that you've submitted. So don't be put off by that. It doesn't mean anything other than they want some more information. All children will go through having their biometric enrolment, so you must make sure that your child has sufficient ID, passport being the best form of ID, before you apply. And other than that, all of the evidence that proves you are in regular contact with the child, you see the child, see your child regularly, and all of your involvement with the child is extremely important. So call logs, chat logs, flights to and from your country, any money transfers or remittance slips, all of that will then provide more evidence for the Home Office to assess your circumstances. So in a nutshell, those are the two rules that you have to deal with if you're applying for your child for entry clearance. It goes without saying, but I'll just say it for completeness, that the child must be under 18 years of age and be financially dependent on you. Those are the two rules. If the child is over 18 and is financially dependent on you, I would have to have a look at that particular set of circumstances to see if the second rule applies. But usually that is set in stone. Child must be under 18, must be financially dependent on you, or dependent on you, and not independent. So if the child is living somewhere else, is over 18, married with kids, you cannot make an application for child entry clearance for that child. So I hope that's been useful to you. Let me know in the comments, and I'm always open to suggestions. Do let me know what other videos you would benefit from, and I'll be happy to consider them. My contact details you will find on my website, which I've got a link on my profile, so do contact me if you want me to represent you, and you want to instruct me for any application. Other than that, I wish you the very best of 2025. I hope you are watching this in the best of health, and I look forward to hearing from you. So thank you for watching this video, and I'll see you next time. Bye.